All right, good morning, everyone. So let me continue from where we left on Wednesday. So let's quickly recap what we discussed on that class, which was about the structure of the Malaysian government. So the structure of the Malaysian government is typical to the structure that we see in many other modern nation states, in which we have the three branches of the government: the legislative, the executive, and also the judiciary. So over here in Malaysia, we have the executive, which comprised of the nominal leader, which is still the Agong or the king, and then but the effective administrator or the effective leader of the executive will refer to the Prime Minister of Malaysia, who governs the country, who is the head of government, and he is supported by his cabinet ministers and supported further by the civil servants. As for the legislative, we have covered the two houses that we have in the legislative bodies, in the legislative structure or branch of the government over here in Malaysia. So typical again to what you see in other countries, we have the upper house and the lower house. So remember, the nomenclature is a bit different. The upper house over here in Malaysia is known as the Senate, or in Malay Dewan Negara, and for the lower house, it refers to the House of Representative or the Parliament, or in Malaysia, it's called the Dewan Rakyat, or in Bahasa Melayu. So the members of the Dewan Rakyat are the ones who are elected based on general elections that we have over here in this country that are conducted every 5 years. The details on how elections are done will be something we'll discuss in the next topic next week. Now, for today, we'll cover the last or the third branch of the government, which is the judiciary, which is something that I believe for all of you as students who are studying law, so you may have come across this discussion before. And if you have studied the British legal system, you would expect the Malaysian legal system to be quite similar to the British one as well, because we are a former British colony, part of the Commonwealth. So many things that we have over here in this country are similar to what we have passed down by the British, or we inherited from the British. But of course, right, because of the unique cultural um, demographic that we have in this country, and also with regards to the cultural leadership heritage that we have in relation to the monarchy, and also with the inclusion of Sabah and Sarawak, which has their own autonomy and special rights. So the setup of our judiciary would cover these specific unique features that we have in this country as well. So let's look into this now. So this is basically the structure of the Malaysian judiciary system, referring to the three highest courts that we have over here in this country within our judiciary system. Um, the highest court is the federal court, and then below that would be the Court of Appeal, and then you have the High Court. Below the High Court, you have the lower courts. The lower courts refer to the Sessions Courts, the Magistrate Courts, and it could also refer to a few other specific um, setup or structure that are done to settle certain specific disputes, like consumer disputes, or when it comes to cases of financial personal financial dealings, there is also a certain specific mechanism at a lower courts level. But primarily, what we are looking at today would be the three courts that we have over here: the Federal Court, Court of Appeal, and also the High Court. Now, moving on. All right, so this is how it looks like if you were to transpose the structure or the hierarchy in a pyramid. At the top of the pyramid is the federal court. We have special courts. Yes, that will be something that we have to cover later on. The High Court is divided into two: High Court in Malaya, that refers to Peninsular Malaysia, right, which where we are in, and then the High Court in Sabah and Sarawak, or Borneo. So this is something that was given to them as a special privilege, in which the states of Sabah and Sarawak, collectively known as the Borneo section of the Malaysian Federation, right? uh, they have their own high court system, where the judges in the High Court in Sabah and Sarawak predominantly should be from the state of Sabah and Sarawak. So these are something that is given to them based on the negotiations that was made between the Federation of Malaysia uh, when Sabah and Sarawak agreed to join the Federation back in 1963. Now, the lower courts, as you can see over here, we have magistrate court. We have also court for children, especially created to hear cases with regards to child custody and also for juvenile cases. So these are the things that would be these are cases that you will find being brought forward to the attention or for the purpose of judicial decision, right, at the court for children. Right. You don't need to remember this. Obviously, it's too many names over here, but these are the Lord Presidents that we have in this country since 1963. So I've mentioned this before. When we got independence in 1957, our first our first Lord President was an Englishman, an English judge. I talked about this a bit during that particular topic, in which Tunku Abdul Rahman, our first Prime Minister, believed that it was okay for us to try and take control of the administration of the country step by step, gradually, rather than um, uh, totally at one single go, because we need to have a period of transition in which we learn from the experience of the British officers, especially when it comes to some of the key structure of the government, and the judiciary is one of them. So I think in many ways, the Tunku was right, because at that particular point, even though Malaysia had Malaya at a particular time, had quite a number of law graduates who were practicing law at various levels, serving as magistrate also across the country, but there were none who were at the senior level. So because of that, if you were to propel or immediately put someone, a local person, to become the Chief Justice or the Lord President, probably may not be suitable yet, right? So that was the reason why the Tunku made that particular decision. Now, just to look into the last two names over there, the two recent Lord Presidents that we have, and the current one as well, those are two quite unique example, because prior to the last two names that you see over there, all the Chief Justice, other than the first one who was a Englishman, all the others are Malay male Muslim. So what was quite unique was that back in 2018, you see the name over there, the second last name over there, Richard Malanjum. Tan Sri is a title, right? In case uh, you don't recognize that, it's not a name, right? Richard Malanjum is not a Muslim, and it's not only that he's not a Muslim, he is also from the state of Sabah. So, as someone who is from the Borneo side, or the east side of the Malaysian Federation, that was the first time that we ever had this. So, it was a big milestone in many ways. Now, after Richard Malanjum retired, he served as the Lord President for just slightly over than 1 year. He was replaced by, or he was succeeded by, Tengku Maimun. Now, the word Tengku over there actually means that she has royal blood, right? But more importantly, her name is Tengku Maimun binti Tuan Mat. Binti in Arabic means daughter of. So this is a lady. So this is the first time ever in our history that we have our Chief Justice a Malay Muslim lady, right? So a female Chief Justice definitely is a big milestone, in many ways achievement when it comes to uh, female equality, when it comes to succession, breaking the glass ceiling, so to speak, because prior to that, that was considered to be, if not difficult, if not impossible, it would be considered to be very, very difficult. All right, so it's just one point for us to look into that. Now, these are the uh, points that you can read. This is part of the slides that you have already on the on Open Learning. So I'm just going to highlight a few key points. The federal court, one of the main aspect of it is or main duty that it has is to settle dispute between the state and federal government. Have you ever had lots of disputes between the state and federal government? I wouldn't say a lot, but there are quite a number, especially in the last 12 years or so, where we have had our political um, scenario in this country to be a bit more balanced, I would say, in the sense that none of the parties that won the election won it with a astounding or big majority. So because of that, we always have we have had in the past 12 years uh, several situations where the federal government and the state government do not belong to the same political party, are not ruled by the same political party. So because of that, there would be disputes. The state governments would, for example, ask for certain rights to be given back to them, or certain autonomy or certain control to be given to them. The federal government would refuse. So because of that, they need to settle this in the court. So in most cases, I would say when it comes to disputes that you have between state and federal, the federal always have the upper hand. Whether that's because of political influence or something similar to that, that is difficult for us to really discuss without looking into further details, right? Which we won't do in this class. Now, the other important aspect over here also is that the federal court listens to appeal cases from the Court of Appeal and also High Court, but not all cases. I think you know this already, being law students. Not every single case that you have uh, brought forward into our judiciary system can be brought to the level of federal court, because if that's the case, then the federal court will not have any days for them to rest, because the federal court by right should be listening to only major, important, right, cases that may set certain precedents when it comes to the law, and also when it comes to cases that are really high profile, and when it comes to damages, right, financial damages that are seek from either party, the quantum that is being disputed is huge. So specifically on that particular regard, right, it's that the number is 250,000. Civil cases that involves claims of less than 250,000 cannot be brought to this level. So for example, if you were to sue someone and you are asking for 100,000 ringgit only for damages, right? If you lose that particular case, you can't bring it up to the level of the federal court, right? It settles only at the high court. That's it. Now, the Court of Appeal would hear appeal criminal cases only, and it would hear only civil cases that involve claims of at least 250,000. So basically, what you have is that 250,000 is the line, right? When it comes to cases that can be brought both to the Court of Appeal and also the federal court. Any amount or that is below 250,000 settles at the level of the high court. That's it. All right. So maybe in a manner of speaking, if you want to sue someone to give you more chance for you to appeal in case you lose, sue that person more than 250,000. Right? Because if you were to sue less than that, ask for less than that, if you lose the judge, if you didn't get the judgment that you prefer at the high court level, then that's it, right? You can't appeal anymore, right? There's no avenue for appeal. The High Court, as stated over here, is authorized to hear cases of all types of crimes and offenses committed by citizens and also non-citizens, and also hear appeal civil cases from the lower courts that involve claims of more than 25,000. So generally, as you can see over here, right, when it comes to civil cases that is between 25,000 ringgit up until 249,000 ringgit, that is settled at the level of the High Court. But if it's below than 25,000, settles at the lower courts level. You may think that, I mean, who wants to bring judgment, or who wants to sue someone or ask for claims for more than less than 25,000? There's actually a lot when it comes to consumer disputes, for example, between the consumer and the retailer or the business supplier. So the cases can actually be involving items or disputes of small amount of money, relatively small amount of money, 1,000 ringgit, even less than that. There have been cases that you have in the lower courts where when you buy something online and then it's promised that it is of a certain quality and the price is quite high. So when you got the item and you realize that it was a counterfeit item, it's not original, it was actually so the price was not suitable to the quality of the item is not suitable to the price. So when you sue the online retailer for something like that, right, it would be something very small, but it will be something important also because you don't want retailers or business people to take advantage of consumers. Consumers have rights, so if you have cases like that or disagreements about that, you can bring it to the attention of the lower courts. Okay. Now, the special courts that we have include the military court, the special royal court, the military court, as quite commonly practiced in many other countries. Also, members or personnel of the military do not cannot be charged as civilians, so they will be charged in the special military court. Special royal court is something interesting, unique in our country because we have kings, as you know, we have 9 Malay rulers over here in this country. And from these 9 Malay rulers, also, you would imagine there are many branches within the family, cousins, second cousins, uncles, and so on. So, members of the royal family in the past used to have absolute immunity, especially the Malay rulers themselves, right? The sultans in their respective states, and also the Yang di-Pertuan Agong. But uh, uh, in one particular instance back in the 1980s, our prime minister back then, interestingly enough, was Dr. Mahathir himself. He brought forward the proposal of an amendment to the constitution to amend that particular part of the constitution. So as a result of the amendment, excuse me, members of the royal family now can be charged, but not in the normal court system. So they have to create a new court now. They call it special royal court. Sentencing is imposed upon consent from the Attorney General. But I have to say, though, that this special royal court exists in theory in our structure, but it has actually never heard any cases since it was established back in the 1990s. Right? So, but I won't come into that on to why exactly that's the case. Now, there are state courts also. Sharia law over here in this country is part of the responsibility or jurisdiction of the state religious department. So there is no centralized federal Islamic law over here in this country. So because of that, there could be certain cases where um, certain actions are considered to be illegal for Muslims in one state, but in another state is considered legal. So that's actually something quite interesting if you actually go deeper into this. Why is it that there is no centralized federal Sharia court system? The reason is something that you can relate to the period of British colonization. If you remember back what we covered during about that particular time, the Malay rulers, even though in theory or by name they were still the head of government and the head of state of their respective states, they didn't have any real powers. The only executive administrative power that they have was to act was were issues or areas that are in relation to culture and religion, the Malay culture and religion. So because of that, right, each state, right, as a result of that particular setup, uh, um, structured by the British, they had each state had developed their own Sharia laws, Sharia court system also into a certain extent, which is quite unique, right, between one state and the other. Now there is a bit more. In the last 1 or 2 decades, there have been quite a number of effort trying to streamline that, because you don't want to have a case situations where things are becoming completely illogical to the point that something that is clearly wrong, right, in one state is legal, the other one is illegal. So because of that, there are some effort, right, from the federal government trying to streamline, but still, state governments and the state religious department still maintain their own autonomy when it comes to their own Sharia court. Customary court is the unique court that I indicated just now that was given as the right of the people of Sabah and Sarawak, uh, created specifically to hear cases of offences against the customs of native ethnic groups of Sabah and Sarawak. So this is something that is quite unique because in Sabah and Sarawak, prior to the coming of the British and prior also uh, before they joined the Federation of Malaysia, uh, land laws or land titles, right, things like that was not really were not really regulated very well. So there are many native groups in both Sabah and Sarawak who would claim that this is my native land, and then sometimes you have overlapping claims. So to hear cases like this, right, especially needed something that is specifically created, right, and judges who are also knowledgeable about the entire scenario, the entire history and culture that you have uh, uh, that involves these people. So, which is why it becomes something which is quite necessary for the government to have this in order to protect the rights of the native people in Sabah and Sarawak to be able to practice their culture, retain their heritage and culture, retain their ancestors' land. But then, when it comes to dispute, right, you need to bring it to the attention of people who are knowledgeable on all these arguments, not just someone who is without any particular attachment to the situation. All right, now this is just a matter of example. Right? In case you do not know how things work, I'm sure this is not something that is a problem for all of you being law students. How does it work exactly when it comes to cases from the High Court to the Court of Appeal and Federal Court? How does it work? So this is one example. Now this is referring to the case of a prominent political figure over here in Malaysia in the past and also still until today, a person by the name of Anwar Ibrahim. Anwar Ibrahim was a former deputy prime minister during the time of Dr. Mahathir when he was the prime minister for the first time back in the 80s and 90s. So Anwar Ibrahim was his deputy prime minister between 1994 and between 1992 and 1998. So in 1998, Anwar Ibrahim was sacked, and after he was sacked, he was charged for a number of crimes. One of it was this sodomy. Now, in case you don't know, also over here in this country, sodomy or anal intercourse is still a crime, right? So Anwar Ibrahim, now I won't come into the details of whether this is something which is concocted by the government or Dr. Mahathir, whether it was a conspiracy. You can Google his name, Anwar Ibrahim versus Mahathir. You will find tons and tons of references. If you want to go deeper into this case specifically, look into case of Anwar Ibrahim sodomy 1998-1999, so you can find greater details about what happened during the trial. But to cut the story short, Anwar Ibrahim was charged for sodomy. Um, the victims were allegedly his former driver and uh, uh, his not stepbrother, his someone close to his family, right? Someone who younger than him but close to his family. Now he was charged. He was brought to the High Court in August 2000. The High Court gave the verdict that he was guilty. So as a result of that, he was jailed. So Anwar Ibrahim and his lawyers later on filed an appeal at the Court of Appeal. The Court of Appeal upheld the judgment made by the High Court, so he remained in jail, so guilty still. But he went on to um, further exploit or utilize the process, the judicial process over here in this country, brought his appeal to the federal court, and in September 24, much to the surprise of everyone in the country, in fact, the federal court overturned the verdict of the High Court and also the Court of Appeal and declared Anwar Ibrahim not guilty. Now, the language of the language of the judgment, or the way it was explained in the written verdict, is something that I think for law students is interesting for you to look into. The federal court, in a way, did not want to offend the Court of Appeal and the High Court, so they mentioned in such a way that that they do not uh, uh, absolutely consider the judgment or the verdict given by the judges in the Court of Appeal and High Court to be wrong, but it just simply said that that are based on certain technicalities, right? Um, one cannot rule out that there are some reasonable doubt, especially when it comes to certain um, uh, key aspect in the evidence that was presented, in terms of the dates, in terms of the alibi that was presented. Certain things did not quite make sense, or did not quite doesn't seem to synchronize very well. So as a result of that, the federal court believed that it is better for us to set this man free, right? Declare him guilty, rather than continuing to condemn this person with a guilty verdict, even because there are some doubts, right? Some reasonable doubts that can be raised. So as a result of the judgment made, or the verdict made by the federal court, Anwar Ibrahim was released, and he became later on active again in politics. Now, he became active in politics between 2004 2005, and he took a break for a year or two before he became active again in politics. And eventually, he became a threat again to the government, and he was charged again for another. This is a different sodomy case, allegedly committed by him to a former intern who worked at the office of his political party. So in this particular instance, it was the other way around. The High Court, right, gave the verdict not guilty, so he was free. But the government filed an appeal at the Court of Appeal. So when the Court of Appeal heard the case, the Court of Appeal said he was guilty. But he did not go to jail straight away, right? Because, right, Anwar Ibrahim's lawyers immediately made a statement that we are going to file an appeal at the federal court. So the sentencing is postponed. Now, the case was finally brought to the federal court, and the federal court actually upheld the verdict given by the Court of Appeal. He was guilty, and he was immediately jailed after that. So Anwar Ibrahim remained in jail between February 2015, after that verdict given by the federal court, up until the election, after the election in 2018. Right? So that's the scenario that we have over here in this country. I do not want to cover in this particular video about the issue of uh, the freedom of law that we have over here in this country, whether the law and judges are free from any influence from the government. That will be something that perhaps you can raise in our class next week. I'm more than happy to discuss some other related cases that can perhaps um, further enhance our understanding about this particular issue. Now, we do have the death penalty over here in this country, even though a recent reform that was done made it not mandatory anymore. It's more based on the choice of or the judgment given by the individual judge. However, these are the crimes that you can see that are punishable by death. Okay. Now, these are some of the points that I normally cover when we talk about crimes associated with foreign nationals over here in this country. I At times I don't feel comfortable talking about this because it seems that we are stereotyping and being prejudicial towards foreign students and foreign visitors to this country. But this is something that in talks I have given to new students, not only over here in KDU, but also in other places, new international students coming in, we are asked to remind international students not to get involved into crimes like this. Uh, yes, definitely the numbers of students who got involved into crimes like this are very few, But these very few cases tarnish the image of the international students in general, particularly students coming from Africa. So prostitution is one, extortion, cheating, right? You can read the details of this in your slides later. Drugs remains a big issue, right? Over here in this country, drug abuse, right? Even though we have for many years the death penalty for drug trafficking, but it remains a problem. So that will be an issue that I would hope you can share some light, some opinion, your own opinion in the tutorial question after this. All right, thank you very much for your attention. So please proceed to the tutorial after this. Answer the questions. Please try to elaborate your points as much as possible so that so that I can know exactly uh, why you made these arguments, right? So try and not to say provide evidence, but provide something that supports why you say or write what you write. All right. Thank you very much. I'll see you guys next week.